Last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and I appreciate the visceral response of the last speaker. I think it was interesting to hear his level of agitation, because I'm looking at the red flag law that was passed out of our committee last October, and there are multiple conflicting issues, I suppose one might say, with regard to due process. But what I found interesting is this ex parte order thing. That is always a very, very dicey piece of evidence for those of us who've actually tried cases, literally tried hundreds of cases. That is a very, very dicey issue. And here you're allowing an ex parte order. If a petitioner makes an avowal that this person, that the respondent, ultimately the respondent, it poses a risk of imminent personal injury. But what is that based on? Either actual knowledge of an interaction between the petitioner and the respondent, or another individual, if the petitioner believes that somebody else is credible and reliable. So you get an ex parte order issued on hearsay by somebody. This is not like doing a search warrant, which would be done on a reliable informant by an officer. This is by John Doe on the street who ran into somebody in the bar who was telling him about so-and-so. And he said, well, they seem like a good guy. I felt like I could trust him. That's the kind of due process that ain't due. And it certainly isn't real process. With that, I'll yield to my friend from Florida.